Mr. Downey was arrested on the 19th of May 2013 at Gatwick Airport when he was en route to Greece. On his arrest, he produced a letter stating that he was free to enter the jurisdiction without fear of arrest. Despite that letter, he was charged by the Crown Prosecution Service with 4 counts of murder. Before he was charged, my consent was sought, as the law requires, for him to face a charge of causing an explosion, and I gave that consent. I believe that it was right to do so, and I remain of exactly the same view today. As acknowledged by the judge, the allegations faced by Mr. Downey were of the utmost seriousness. The bombing was an attempt by the Provisional IRA to bring their terrorist campaign to London and to attack armed forces personnel who were on ceremonial duties. Whatever the circumstances in which the letter had been sent, and it is now clear that its assurances were wrongly given, it was right that the matter should be tested in court. Neither I nor the Crown Prosecution Service were prepared to accept that the letter and the circumstances in which it had been given were such as to automatically prevent Mr. Downey's prosecution. The prosecution of a very serious offence of this kind is plainly in the public interest. The court heard full argument and considered a great deal of documentation. The judgment given is a detailed and careful assessment of the case and the circumstances in which Mr. Downey received his letter. It's worthy of note that the defence offered 4 grounds on which they argued that the case should be stayed, and that on 3 of those grounds the judge found for the prosecution. At no point did the judge suggest that it was inappropriate for the prosecution to be brought. Indeed, he noted, and I quote, that the public interest in ensuring that those who are accused of serious crime should be tried is a very strong one. My own very strong view is that this was entirely appropriate and proper for this matter to be considered in a court of law. Notwithstanding that, the judgment has now been given, and the Crown Prosecution Service and I accept that judgment entirely. We do not consider it gives rise to any prospect of a successful appeal, and we have therefore notified the court that we will not be appealing. My sympathies, above all, are with the families of those who died and with all those who were injured on that day.